Welcome back to another thrilling episode of Elixir Talks, where we bring clarity to your real estate queries. Today we are going to tackle a common question many buyers grapple with. Can I actually back out of a real estate transaction? We are going to demystify this process, outlining the obligations of all parties involved. Have you ever found yourself in a situation where you notice everyone else making certain decisions and almost instinctively you feel compelled to do the same? However, when you are able to secure the contract or the product, you question your decision. This is called buyer's remorse. Real estate is no different, and this feeling tends to kick in after your offer has been accepted by the sellers, leading you to question your own judgment and even consider cancelling your purchase. In Ontario, once a real estate resale agreement becomes firm, meaning the conditions have been lifted from the offer, there is no turning back for either buyer or seller. Let's break this down with an example. Imagine you as a buyer placing a conditional offer on a property contingent on finance and inspection, valid for 5 business days. Concurrently, you would be getting your mortgage approved by furnishing necessary documentation to the financial institution, which includes your accepted agreement of purchase and sale, along with your salary supporting documents and taxation documents. Meanwhile, also contacting a qualified home inspector to complete the home inspection within this 5 business day period. Once you are satisfied with your due diligence and both conditions are met, you decided to proceed. You will provide a signed document called the Notice of Fulfillment. This is essentially your commitment as a buyer to fulfill the 2 conditions in the original offer, thereby cementing the offer as a firm agreement. Once this notice is handed to the sellers, the deal becomes firm. At this stage, the agreement of purchase and sale morphs into a legally binding contract. Your deposit is held in trust with the listing brokerage. If you decide to back out after this point, be prepared for legal consequences. Moreover, your initial deposit stays locked in the listing brokerage's trust account until a court decision is made or a settlement is reached between the seller and the buyers. Until then, this deposit remains untouchable by both parties and is safely locked in the trust account. Now let us suppose a buyer has an offer for 800,000, but later decided not to get it closed. Meanwhile, the market dipped. The seller is now forced to sell the same property to another buyer for 750K. In this scenario, the sellers can sue the original buyer for breach of contract, potentially demanding the shortfall in the agreed purchase price, along with any carrying cost for the property's extension and any legal or selling cost incurred due to the delays. The key takeaway: in real estate, only place an offer on a property when you are fully confident and committed to the purchase decision. Treat it like any other contract. Sign with prudence and conduct your due diligence properly. That way, the buying and selling process in real estate will feel like a smooth sailing journey without any surprises. Hopefully, this episode proves helpful to you. Feel free to share it with friends or colleagues who are looking to navigate the real estate market. If you have any questions in the realty domain, our stellar team at Elixir is ready to provide top-notch assistance. Thanks for tuning in, and we can't wait to see you in our next episode.